Good afternoon. This is Eric Bowman. I'm joined by my partner, Gary Forster, of the law firm of Forster, Bowman, Lefkowitz, and Lowe. And we are bringing you the finale in our series that we've been doing over the past year on the 11 commandments of asset protection. And we have done these webinars each month since the beginning of 2017. We're glad you can join us today. Throughout the webinar, you have an option to ask questions, and you can drop those into the webinar box, and we will field those questions as you ask them as best as possible. If you have a question we don't answer during the webinar, if you think of something afterwards, please feel free to contact either one of us by phone or by email, and we can address those questions offline. And I have some slides that I will drop in to so you can follow along. Basically, I'll have copies of all the slides. And then what we're going to do today, it's a little bit different from past webinars. We are going to, pardon my screen here, I'll move this out of the way. We are going to basically do a synopsis. We're going to cover what we've done in the past year. And we're just going to kind of do an overview and see what the lessons are that we've learned from the last year's webinars. And so this will be a very broad view. And again, if you have questions along the way, we've got prior seminars that cover each of these commandments in more
detail, in much more detail.
Yeah, so each one, and you know, an hour's webinar, sometimes enough material for 2 hours or more. And we can provide you with those materials and provide you with the recordings. And if you'd like us to present it to a group, we could certainly do that. Gary and I speak on a regular basis to different groups, and we continue to do those and can provide continuing education credit for that as well. So without further ado, Gary, would you introduce yourself to the audience, please?
Hi, this is Gary Forster. We are proud to bring you this wrap-up. Note that there's a lot of material here. This is just kind of an intro. Really, it's like an intro to 11 seminars. So you likely have a lot of questions, and we're happy to field those questions right through the system. And we'll stop to answer any question. This is really kind of just to give you a flavor of the lessons learned. In other words, you know, although we've done the 11 seminars, really 8 or 10 cases now govern asset protection, at least, you know, in terms of current thoughts on fraudulent transfers and where entities should be formed and how offshore planning works. And we're going to hit those high points today.
All right. I'm having a little bit of difficulty here with my slide screen. I may need to exit out here for a second. Please bear with me.
Is it that one or this one?
Yeah, I don't know why my screen is not changing.
You can click it.
Okay. Pardon me, folks. I apologize for that.
All right. The slides.
So as we said, we are doing a review, the wrap-up of the 11 commandments. And just as a recap, here's what the commandments are. And number 1, don't do asset protection. And we talk about what we mean by that. You may transfer assets freely, but not really. And that really talks about the limitations imposed by fraudulent transfers and other time limits in particular with transfers when people are trying to do that to avoid paying a judgment creditor. Buy your umbrella before it rains. More lessons on advanced planning, asset protection, a lot like insurance. It's something that you know, people look for it oftentimes after they need it, and that's too late. So a lesson on planning early. Don't be greedy. And in that one, we talk about how valuation issues come into play. Gary and I also wrote an article that was in the Florida Bar Journal in the December issue of the Florida Bar Journal. So if you have an interest in that, that's quite
we have a copy.
Interesting for the financial folks out there. Choose the terrain wisely, and that deals with issues of jurisdiction, choice of law, venue when you're dealing with asset protection planning. You know, where you plan matters. And it also deals with enforcement issues. So just because, for instance, you plan, create an entity or some type of protective mechanism, maybe in Delaware, doesn't necessarily mean that Delaware law will apply to that entity when it gets challenged. Know your enemy. That one was a fun one that we did, talking about in particular certain creditors that Gary has dubbed super creditors. These are oftentimes government agencies and bankruptcy trustees, and those creditors who have more power than your average creditor to pursue assets, oftentimes not only more power under the law, but more power because they have the resources and the manpower to do so. If it sounds too good to be true, maybe it is. It's sort of self-explanatory. And then, some of the details towards the end, we talk, and planning need not be complicated about, some of the simple things that people can implement right away. And then know who.
And sometimes that's also more effective.
That's right. And some of your most effective early planning, some things that we can really help you with early in the process and without a lot of complication, and oftentimes not without a lot of expense. We talk about trusts. We devoted a whole seminar to that: onshore, offshore, domestic asset protection trusts, and some misconceptions about trusts. And of course, we talk about bankruptcy. And then finally, in the seminar we did last month was involved legal ethics in asset protection, and we covered some issues where people can get in trouble either as an advisor or as a third-party transferee. So moving on to the first of the fun topics, don't do asset protection. And what we really, one of the things we talked about with that one is some of the misconceptions that people have, including courts, when you deal with, when you go into court with asset protection. We've seen some cases where even where debtors did do advanced planning and they did what they were supposed to do, but they were smug about it, and they go into court, and instead of kind of tying it into a total plan and working ahead of time to avoid issues, they go into court and they say, well, you've sued me, but you're never going to collect anything because I'm fully asset protected and I'm untouchable. And it's kind of like when you hit the base when you're a kid in tag and thinking, well, nobody can get to you. And creditors sometimes like that challenge, and so do courts. That might be a good approach in a confidential settlement discussion or mediation, but not so much in court. So one case that really kind of brings this out is this one that we've talked about, is this Kilker case. And I'll let Gary, maybe you want to give a little background on Kilker?
Well, what I wanted to say first was we often get calls where someone says, I really just want to hide my assets. That's probably once a month we get something like this. The idea is not to hide. The idea of asset protection in terms of what it's not is to, what we want to create protections that are available under the existing law, depending on where you live and where you operate and where you hold assets. We use trusts and LLCs for that in general, both domestic and offshore. And what we want to happen is, if there in fact is a creditor or there's litigation, we want to be able to just disclose exactly where the assets are and how they're held. It's not hiding. It's creating a structure that's going to hold up in litigation. That's kind of what we mean by, what asset protection is not. Kilker is a case where a contractor had done some really legitimate planning with what we call domestic asset protection trusts. These are trusts that you can make for yourself, and 16 states allow you to protect assets with your own trust. This came from the offshore wave of self-settled trusts that occurred in the late 80s and early 90s. So Kilker went ahead and did this. He was not subject to a creditor. He was in a business that could potentially see creditors. He's in the construction business, and later, only later, really ran into problems and walked into court in California. He created a Nevada asset protection trust. He later went into court and said, you know what? Real attitude, I was doing asset protection planning, and you can't get anything. And this isn't an outlier case in some senses. It is enforceable in California, but the judge got very upset and basically disregarded the planning he had done. It probably wasn't the greatest choice of planning, but it seemed legitimate. And so even if planning is legitimate, structures are apparently enforceable. If you go in with the wrong perspective, you do tend to jeopardize the plan. As we'll talk about in some later slides, we like to do things that really correspond with other planning, such as estate planning or business planning. We structure things in a way that obviously aids the person both from a protective standpoint and maybe even a business and a tax standpoint can be very helpful. And we like to go into court with total disclosure and backed by the fact that we did things in good faith.
Yeah, and we have a note up here on the screen about the importance of your intentions when you're doing planning. And what we found is some of the cases where people present, you can present the same set of facts, but when you present it as though your intent is just to avoid having to pay a creditor, you can get yourself in trouble. And we had that Kilker case where really legally it was an odd result, but then we distinguished that with BB&T, and that's a 2016 case where this individual, Mr. Ballinger, was sued as a guarantor on a loan. It was a multi-million-dollar construction loan. And in the midst of the legal action, he transferred a significant amount of money. I think it was about $1.7 million into an offshore trust. But he explained to the court in testimony he had, legitimate reasons for doing so for family and estate planning purposes. He had some other motives that was driving him to engage in some planning.
It really seemed like a fraudulent transfer where he'd lose the case, but his intentions seemed pretty good. And also, he had a very interesting argument. His counsel did, I think, a very good job in that case, where if I recall correctly, even though at the time of the litigation, the value of the asset created some insolvency, like he basically got the thing out just in time. At the time of the transfer, it did not do that. He transferred in a way that did not create an exposure to fraudulent transfer because of the value of the asset at the time of the transfer was actually much higher.
And we have some overlap in some of the cases that we look at, but we cite that the BB&T v. Hamilton Greens. We also cite that in our Bar Journal article, and we talk about that in evaluation issues because there was a question there on the value of the property versus the loan that defaulted. And there were also co-defendants. So, basically he had a twofold argument. He said, one, I never expected to be subject to a judgment. I know I got sued, but I never thought anything was going to come of it. And two, I totally had other reasons for my planning. And that brings up another point is, one, we get folks who will call and they say, okay, I've been sued or this is going on and I need to do some asset protection. And frankly, it's too late. And we tell people that we'll do an analysis and we'll go through and we'll see, what avenues may be available. We've come up with some unique solutions for people where you might be able to kind of tuck something away, but not when you're engaging in a fraudulent transfer. It's really something where there's some type of exception available. But by the same token, and this just happened to me recently, I had a client that asks, that's involved in a lawsuit and says, well, I want to do some planning. He wants to have some assets. He wants to preserve some stuff for his kids. He's got one young child. He's married. He says, really one of these properties I have, it's my husband or my wife and I that have always paid for it and own it. It really should be titled in both of our names. And it's really something where he just never considered the way things were titled and the way things were structured. So then, the question is, well, do you have to sit on your hands? And that's not always the case. Some people say, well, you've been sued, you can't transfer, you can't do anything. Well, lawsuits can go on for years. I had a case that went on for over 7 years. It doesn't mean that you have to keep yourself totally exposed and you can't do anything as to any other creditors or just for regular estate planning. You just have to be very careful about it with the understanding that you can't transfer assets fraudulently as to that particular creditor. That's right.
Yeah.
So each case is individual, and it really emphasizes, these two cases, Kilker and BB&T, really show how the intentions of a debtor really make a difference in a case. Commandment the second commandment of asset protection. You may transfer assets freely, but not really. And we start with the U.S. Supreme Court, which this was a case where the issue was whether or not you had a right to transfer assets prior to judgment. And the court said, up until a judgment's entered, yes, the parties can transfer assets freely. That's the Grupo El Mexicano case, Grupo de Mexicano.
So it's yeah, I mean, a lot of people get confused with the right to transfer and the basically rights of the creditor to reach the asset. So your right to transfer is available. That's not like it's really until fairly recently there's really no penalty in creating a fraudulent transfer. That law and that is now shaking out somewhat, mostly in bankruptcy. But you can move assets around as you like. The problem is that the creditor can come and grab the asset from the transferee. So until recently now, where courts are starting to get upset in the bankruptcy context, you could kind of move whatever you wanted to, and then just have to deal with the idea of having made a fraudulent transfer. But you can't really be penalized for fraudulent transfer. Of course, you drag the transferee into the litigation, which is a drawback.
Now let me attach a caveat to that. That you can transfer assets generally as a debtor, and they could be unwound under fraudulent transfer or other theories. But generally, in the heat of the battle, the fraudulent transfer is the main legal concept. But states vary on liability for third parties and for the advisors. So
here's our ethics.
And so we did cover it in ethics. So be careful if you're an attorney or a CPA or financial advisor or a banker, and I call those professions out because all of them have been defendants in lawsuits as accessories for aiding and abetting or in conspiracy actions for fraudulent transfer. And so we'll talk a little later on some of the cases. If you're here in Florida where we practice, Florida case law has said that there's no third party, generally no third party accessory liability, but you still want to be careful because I think that that's going to be challenged later. So, but you have a lot of cases where you have the fraudulent transfer issue comes up and you have defenses to fraudulent transfer. And so we cover those in the second commandment as well. You may, like with Mr. Ballinger, have other reasons for making the transfer. We call that a legitimate supervening purpose.
And we should also kind of outline a little bit how fraudulent transfers work. So in order to go get an asset that's been transferred away from you as the creditor, you have to show that the debtor, the defendant, transferred the asset with the intent to avoid you. That's number one. If you can't show that, you can show intent constructively by generally proving insolvency, that the asset was transferred, that an asset that you can't get came back to the debtor, or nothing came back to the debtor, and that the debtor became insolvent. So they transferred an asset, they got something back that you can't get, or nothing came back, and that the debtor became insolvent, which means you can't go after another asset instead. So if you can prove that, then we look at, well, does the debtor have any defenses? And as Eric mentioned, you have this supervening purpose. My intent was not to transfer away from you. It was to do estate planning. It was to put money away for a disabled child. There's actually a case on that. And then you can see the rest of these defenses. There is a statute of limitations depending on the state, depending on the country, for fraudulent transfer. You can't just bring it in 20 years after the transfer occurs, and then these valuation issues deal with the insolvency issue. And then, of course, you have the homestead in Florida. You can fund a homestead running away from the creditor, literally about to grab you or your account, and fund a homestead and go live in it, and they can't get a thing. That's starting to be chipped away in bankruptcy, but it looks like only in bankruptcy.
Bankruptcy is chipping away at Florida homestead, not from the point of view of the person who owns the homestead, right, but from third parties sometimes.
Well, it's a transferee liability.
That's right. But homestead is very broad. These are all defenses that we've used when we defend these actions. And by the way, having defended them, if you're on the other side, we understand the potential deficiencies in some of these arguments and how to attack them. So there's angles on both sides. Homestead, I'll just use it as an example. You think of a homestead as, okay, your home is protected. Well, what about if you're a farmer and you have a farm? And what about if maybe you're not even a farmer, but you own a farm and you want to rent out the land and you rent that out for income and you're in a rural environment? Does that qualify for homestead protection? And you'd be surprised how broad the homestead protection is in Florida,
especially outside of a municipality.
Outside of a municipality, especially. Not so broad, by the way, to cover the defendant who claimed homestead protection on a building that had an apartment upstairs and a nudie bar downstairs. The court drew the line and said, no, that's not a homestead. But I've seen twin properties, duplexes, sixplexes all make the argument. So again, these are broad strokes on some of this, and we have a lot more detail. If you're interested in that, please let us know if you missed any of these. This is similar to the last. It's more, Commandment 3 focuses on the benefits of prior planning. Plans fail due to lack of planning, and for this one, we wrote an article on this a couple years ago when it came out. This Travelers case involving some folks who waited to the last second when they got sued to try and transfer some assets. And what happened in that was a federal case here in the Middle District of Florida, and the judge was really upset and said, you need to take all the, you take enough money to post a bond to secure the interest of the creditor's claim. And if you don't post that bond in 10 years, they risk, or excuse me, 10 days, they risk, during the course of a lawsuit, they risk being in contempt of court.
And going to jail.
And going to jail. And it was really just an ugly, ugly opinion from the standpoint of, if you were sitting in the debtor's shoes, and it was just because, they were moving assets around a lot at the last minute, and courts do not like that. So, we emphasize distinguishing proper planning from reactivity, and that's where Gary, he's written a book on this. All of this really, to be most effective, needs to be done, when the skies are sunny, so to speak. And I'll let Gary, anything you have to add on that concept?
Well, it's just, start early, start when there's no claims. Sometimes people have a small claim and they think that they can't do any asset protection planning. As long as the claim does not make you insolvent, for instance, sometimes we get a valuation of these claims. You can do asset protection planning. You just have to keep in mind that there's a chance that the planning will not be protective with respect to the small claim. But the best way to approach it is to say, okay, I'm going to start planning. I may have another motive, and it's for things that not only have not occurred or are in litigation, but that I don't even know about. We have a question?
No, we don't have any questions. I check every once in a while here. I keep an eye on the screen, make sure if you have any questions that we're addressing those.
They're mesmerized. This is a lot of material.
And we list some of the ways there. There's a lot of ways. And if you, by the way, again, if you're on the other side of this and somebody owes you money, and they're moving assets around, there's some ways you can put the squeeze on. There's a lot of ways to attack transfers, not just through fraudulent transfer, but other arguments that can be made as well.
And some of the practical arguments really involve the fact that you just have to keep in mind that the courts go through a trial or they go through a litigation and they've rendered a judgment. Typically, that same court would be involved in the collection action. The courts really don't want to be in a position where they can't enforce their judgment. So they're almost always going to favor the creditor. So you want to look completely clean and having planned well in advance to these type of claims. These cases obviously become these appellate opinions because they're controversial. But you know, in 24 years, I've never had a plan breached one time, because we do it as a planning mechanism, and it's very unattractive to try to reach through that whenever any litigation comes up.
Good points. All right. The fourth commandment is, we termed it, don't be greedy. We probably don't have a career in movie marketing, or I don't think anybody's going to buy the movie rights to this series, but maybe a book is on the way. But in any event, in this one, we dealt with issues of valuation that come into play when we're doing analysis, in particular on fraudulent transfers. As Gary alluded to earlier, oftentimes a fraudulent transfer is proven by showing that a debtor made a transfer of an asset and in return received less than reasonably equivalent value, and that transfer left the debtor insolvent. So, you know, solvency comes down oftentimes to a balance sheet test of assets and liabilities that existed before and after a debtor makes certain transfers, and then you have questions with reasonably equivalent value. So, you know, how does that factor in the fraudulent transfer analysis? Well, I own a what's the fancy watch? Gary's a watch guy. Hublot. I own a $20,000 Hublot watch, and I need cash because I've been sued. This is a hypothetical, and you know, well, is that a $20,000 watch? Well, maybe, but if I sell it on Craigslist and I need to sell it this week, I might get 8. Is 8,000 reasonably equivalent value? It depends. A lot of it depends on the context.
So, and we might want to set the table on, again, the idea would be, if you made the transfer, right, that you have another intent, and someone says, okay, I'm going to prove that you fraudulently transferred. I'm going to prove it constructively by showing that you went insolvent, that you didn't get back reasonably equivalent value and went insolvent. So what Eric's saying is, well, if I go ahead and sell the thing on eBay or whatever, maybe I did receive reasonably equivalent value back, and you can't show that I intended, you actually intended to avoid you, so you're out. The creditor in that case can't prove fraudulent transfer, and it's hard to really reach any asset at that point.
Yeah, another example might be, you know, maybe one that kind of shows it in the fraudulent transfer context is, and I'll take an actual example where somebody comes in and they're a medical practitioner, and they are getting ready or have been sued or getting ready to be sued. And they're going to be sued, but they say, look, I'm going to be sued. Let's say the claim, it's, you know, the plaintiff wants $1 million, but I don't have any liability. I didn't do anything wrong. So that's a disputed claim. Not only that, you know, the plaintiff may not win. You know, the claim may not be worth that much. So, you know, then the physician says, well, am I stuck from doing any planning? Because if I move assets, you know, I end up becoming, I've got to take this claim into account, and how do I value this claim on my balance sheet? Well, $1 million disputed claim might not be valued on a balance sheet as $1 million. It might be valued, you know, for instance, maybe there's a 20% chance of success on the plaintiff's side, and maybe the real damage is, if there is success, or $500,000. Well, maybe you're looking at something that's worth $100,000. I'm not a professional valuation
you're
person. You're
valuing not the asset, but the claim.
You're valuing the claim for the liability purposes, to show I didn't make a fraudulent transfer because I accounted for this, and I moved some assets. I did an offshore trust with Gary. We did some stuff in Nevis, and I did some estate planning. But I left a nest egg of $200,000 to deal with this claim, and then you get hit for $1 million.
And we've done that.
Yeah,
we've done that. And that left the nest egg to avoid the insolvency issue. It's a great thing to do.
And we may like to have somebody come in. You know, another example, again, like a loan guarantor, where you have a contingent obligation. That's what you had with Ballinger, where, you know, his obligation wasn't the full amount that he was being sued for. He was one of several defendants. So what's the value of that claim? It's a very technical. We could probably spend a couple hours just talking about that, but it's a good thing to be aware of.
On it, which took a lot of hours.
That's right. And so we've got another slide there. We're almost about 12:30, again, if we're doing planning when there's something negative out there, we want to make sure we account for that. We're not going to advise you to take every penny and put it offshore probably. So the fifth commandment of asset protection is to choose the terrain wisely. Another issue that Gary and I have gone back and forth. I've actually have a little bit different views on this, so I'll let Gary run on this one.
Oh yeah, the planners and the litigation people have different views on this. The litigation people always win. We never tell them that, but they pretty much always win because they have to go to court and they know what the judges are going to do. So what this really involves is we use a lot of LLCs and trusts, and you know, each LLC or really and trust is governed by an organizational statute. So if you have an LLC in Delaware, it's going to describe what protections apply to that LLC in the Delaware statute. You also you can be in Florida, which does not have that protective a statute, and form a Florida company, or you can say, well, I want the more protective LLC, so I'm going to form a Delaware LLC. The question becomes, if you utilize the Delaware LLC statute and you start to do business in Florida with that statute, you know, what law applies? Corporate lawyers and planners like myself always really interpreted this under what's called the internal affairs doctrine. So if I create a Delaware nickel, I've got a Delaware nickel. If I create a Florida nickel, it's a Florida nickel. But because these, as we had mentioned earlier, these judges really want to enforce these collections on judgments that have occurred in their courts, they really reach. So for instance, in each of the Delaware and Florida statutes, when it talks about the LLC that's being created under that statute, it talks about the LLC. And the LLC in Delaware is a Delaware LLC. The LLC in Florida is a Florida LLC. But if you get a bad actor, right, like Miss Barber in the Wells Fargo v. Barber case, who had a $64 million debt and tried to run away and hide all her assets, the courts are going to do absolutely everything they can, even though she actually had a Nevis West Indies, which is a very strong, I took part in drafting that statute, a very strong LLC statute, which likely would have protected her from the claim in the Wells Fargo case where she owed so much money. The court says, well, you know, your assets are in Florida, so I want to grab those. You're in Florida. The case is brought in Florida. So why don't we, instead of enforcing the Nevis LLC statute, which has the protections, why don't we just call it kind of a Florida LLC and crush you? And that's what they did. That's what they did. Now there are very different outcomes under different circumstances. This was a bad actor. We had talked about the other guy who ran into court and said, you know, you're not getting anything I have. But that's what happened in Florida with respect to a Nevis LLC. Now we had an Alabama case where the Alabama case in Arroyos completely refused even to act on a Nevada LLC to bring a lien on that equity, even though, you know, it seemed pretty clear that they could at least have brought an action under Nevada law, but they wouldn't even act on it. And we have a court in Colorado, a federal court in Colorado, that similarly said, you know, it's a Colorado LLC. We're going to apply the protections in Colorado and not expose it I think that was in Arizona, which would have allowed that, even though the parties are in Arizona. It's a Colorado LLC and it's protective. So the courts, I think in general, have been pretty reasonable in respecting the applicable statute. But when you have a bad actor and a fraudulent transfer, or someone who's got the wrong perspective with the court, it's kind of like you can throw your hands up in the air. Do you agree with that?
Yeah, a lot of it has to do with the defendant, and a lot of it, I would say, you know, some of it also has to do with the claim. If it's just a loan and you're dealing with a financial institution and they know what the situation is. You know, they go into it eyes wide open. You make a full disclosure of assets. We saw that with the case up in Delaware, where the court, you know, applied Florida law to honored self-settled trusts in Delaware over a Florida resident, but that was where everything was disclosed to the financial institution.
Yeah. Also, well, that court wanted to honor the protections. It was a you know, if you bring the case in Delaware for a Delaware entity, also the odds go way up, even if you were operating in another state. That was a mistake that the creditor made, way up. So we can, you know, talk. I think we hit that in another slide, but you know, if you're not going to go offshore with a foreign trust and remove assets from the jurisdiction of the court, and you want to do it in Nevada, for instance, you know, it's a really good idea to have a Nevada trustee and hold the assets in Nevada, because what's probably going to happen is a Nevada court is going to hear that case, and a Nevada court is much more likely to uphold that Nevada's protective statute than, for instance, a Florida court.
And jurisdiction becomes very important. And I had a case here in Orange County about maybe a year ago, 2 years ago, where we were retained to represent a Nevada trustee who the creditor tried to sue here in Florida. And we made a limited appearance only for the purposes of arguing against jurisdiction. And the whole goal there was to get the Florida court to kick it out on jurisdiction and tell the plaintiff, if you want to sue this Nevada trustee, you've got to go to Nevada, because Florida may not honor a Nevada trust, but Nevada is certainly going to honor a Nevada trust. So we want to push the playing field out to Nevada, where we're going to have more favorable jurisdiction, more favorable results. So again, it's somewhat complicated issue, but we just want you from this commandment, the big pictures, we want you to be aware of the implications of picking a Delaware LLC or a Nevis entity or a Nevada entity, or doing something here in Florida. We also get into the single member, multi-member LLC issues when you talk about jurisdiction. There's a lot to it. So the sixth commandment, pardon me. Let's see, we have another one there. By the way, that's the Gettysburg battlefield, and the one on the screen there is the York battlefield. If you get a chance to visit either of those, Gettysburg is pretty spread out, and there's a CD in the gift shop I highly recommend, and then go out and tour the battlefield. You could spend days out there. I think you can hear the ghosts. The sixth commandment of asset protection: know your enemy. Yeah, we're all still in the battle atmosphere.
No, yeah, that's a good.
Who can reach assets transferred to a protective structure? And that depends on the class of assets, how they are owned, and who intends to seize them. And why does that become important? Well, we list the cases.
Oh yeah, no, this government claims and IRS issues are a disaster. There's really only one reason. I mean, well, there's two reasons, I should say. The creditor statutes on collection for government entities are much more favorable to the creditor. And the bigger issue is that there's really no monetary constraints on the government. They can bring these cases. This one, affordable media, it's called the Anderson case there. It's the second one there. I mean, the government went after them. They did a fraudulent transfer out to the Cook Islands. They went to the Cook Islands to register the judgment and to finalize the claim. Cook Islands ended up changing its law. I mean, they ended up with pennies on the dollar, actually, in that state. But that would never happen with even a wealthy private creditor. It just doesn't happen.
Yeah, if you're dealing with, if you owe the IRS, or if you've done something to rip off a bunch of consumers, or I should say allegedly rip off a bunch of consumers, and the FTC is looking for your assets, any federal agency, including bankruptcy trustees, it's a different ballgame. Not only is it a different ballgame on a practical level, it is with the law. The fraudulent transfer time periods are extended. Some protections that are available, for particularly like tax as against homestead. Homestead is protective against pretty much anything except tax. bankruptcy laws, the bankruptcy, when the bankruptcy code was reformed in 2005 under the Bankruptcy Reform Act, there was a particular concern about the growing trend of self-settled trusts. And so there is a 10-year look back that applies to self-settled trusts in bankruptcy. And so we deal with that in our trust case. That's right.
If you do a transfer to a self-settled trust, whereas after, generally either 2 or 4 years, you don't have to worry about those assets being unwound at all. Whether there was something going on, whether there wasn't something going on, the statute closes out. But now it's 10 years in bankruptcy. So we have people, sometimes they want to file bankruptcy. Bankruptcy is a very, very serious decision. If you have any assets, you're probably going to have to give them up.
We generally tell people, and that's one of the commandments, is bankruptcy is for the non-planner, and we don't want to be in bankruptcy unless you're really bankrupt.
You're insolvent, yeah.
The next, then, 7th commandment of asset protection is that if it sounds too good to be true, maybe it is. This really is one we had some fun with. We just to get to talk about, if you go online and you Google asset protection, you will get all kinds of interesting things that pop up. Attorneys, non-attorneys selling gobbledygook. And we spent a whole hour in a webinar sort of going through, some stuff works. There's a reason to use offshore structures. Sometimes that works, but you have to know what you're doing. You have to know how to set them up. You have to know what assets work, what trustees and managers work well with that. There are some exempt assets under Florida law and federal law, but this notion, for instance, that you might take an apartment building and put it in an anonymous land trust, and that will keep you from having any liability. That's one that I hear. Put your real estate in a land trust and avoid liability. Well, if somebody slips and falls on the apartment complex property, they don't really care if they find you. They're going to sue and crack into the apartments.
Yeah, there's no real privacy.
Spousal transfers. Gary was almost an expert witness in a case where another lawyer from Miami or New York or something told this poor guy who was being chased in connection with some of the clawback issues in the Madoff case. Somebody told him to go ahead and transfer all of his assets to his wife. That was just terrible advice.
For him.
For him,
it was very, very bad advice.
And but funding a trust for your own benefit, that's one. You can do that. We have domestic asset protection trusts. We have offshore self-settled trusts, and sometimes in the right jurisdiction, the right context, they work.
Sometimes we have protections associated with married couples, and that married couple can take jointly, which creates some protections against creditors of one, but not both spouses.
That's right.
But single people, there's some limitations on asset protection under certain circumstances, and we would, at least contemplate utilizing a domestic or offshore asset protection trust in those cases, for sure.
And that's a good segue into Commandment 8, which is planning need not be complicated. Mm-hmm. And oftentimes, here's a litmus test for a plan, is think of if you're doing this for a client, if you're a lawyer, you're involved in this, and you have a client that's doing some asset protection, or you are a client, can you explain it? If you're sitting in a deposition, can you explain what you have and why you have it? And if you have no idea what's going on and you can't explain why something was done, it's just going to look bad. And so that's just a good place to start. And oftentimes you just accomplish more that's going to be defensible, more easy. The other problem we have with, oftentimes is you'll have clients who want something and then they create something that's unmanageable. Or we've seen that from other folks where they've got this, there's this complicated structure that's set up, and the client either it's unmanageable from a business, maybe a tax standpoint, or they never implement it because it's just so unwieldy.
Well, also on the explanation, that's actually a great point, because the ones we've seen that are overturned in many cases, it's not so much that it's not a layered plan,
The problem is that there's so much going on. There's so many moving parts that it starts to look like a sham. It starts to look like, you know, this stuff was just created as kind of a layover to something that the client can really just immediately access whenever they want, at any time, could liquidate, could move. It serves no other purpose, but it's just this strange Andromeda strain of a plan. And judges tend to throw that out.
Yeah, we've seen that. You see it with trusts. People write these exotic trusts with all these provisions where the grantor.
But they can terminate it.
Yeah, they could sneak in the back door, and the judges throw those right out and say this is essentially a revocable trust and there's no protection. You know, what are the simple things? You know, we should do a webinar maybe for the everyman, kind of, you know, what you should be doing now. Titling, that's, you know, Gary mentioned tenants by entireties. That's available to married couples. A lot of your assets, if you're married, bank accounts, securities accounts, unless it's, you know, a retirement account, which also, by the way, is protected here in Florida. You know, titling things in the name of you know, husband and wife. There's some technical issues with that. So if you have questions on that, we encourage you to call us. It's pretty easy once you understand it, but it's something that we see screwed up on it pretty often. Exempt assets, traditional spendthrift trusts. If you have, you know, children and you want to leave assets, that's, you know, that's the oldest form of asset protection. And then, you know, we could spend a whole seminar talking about protective entities and the benefits in particular of limited liability companies and why and how they should be used. And insurance plays a role. You know, we like insurance as the low-hanging fruit. So it's not an either-or proposition as between asset protection and insurance. Instead, you use asset protection, combine it with some good insurance, and then you allow the creditors to get to insurance in certain circumstances where there's liability.
Well, it also can fund some of the litigation as well.
Sure. You provide your defense. We're coming up on a time. We got the 8th, 9th, 10th, and 11th commandments. Are we going to get there?
Are we doing 50 minutes or an hour?
We are, well, it's a 1-hour webinar. We started at 12:02, so we technically have 2 more minutes, plus we have 10 minutes for questions.
Okay.
I don't want to bail off. Oh, wait, hold on. Here we go. We've got a question.
Okay.
I just have to pull it up here. All right, so the question is a Ladybird Bead a good tool for your primary residence for the common person, for the everyman? Okay, Ladybird Bead, if we're talking about the same thing, is a, I don't know why they call it a Ladybird Bead, so much of it, but it's essentially you keep a life estate. It's where you deed the property to somebody else and you keep a life estate. And I just had this come up not too long ago, and it can serve a purpose. So be careful with it. But you know, my understanding in Florida when I looked at the issue was that that you still qualified for homestead, because the issue with your home in Florida in particular is the homestead protection. So you don't want to screw that up.
Yeah,
and so Ladybird is a mechanism.
No, it serves to divide title, so you don't have to go through any probate on the death of the resident of the property. So let's say mom has a house and signs a Ladybird deed that to son. Mom can stay in the house until she dies, and then it automatically retitles to son without another deed, without the need of another deed, without any probate, without anything.
But I don't know that it's really an asset protection.
Well, the issue, I don't think it's been really resolved in Florida. It's not that I think mom still would qualify for protection of her interest during her period of residency in the home. So contemplate this. Son is sued, right? And loses a judgment, and now we look at what son has. And one of the assets is what's called the remainder interest in the property. Is that protected from son's creditors? Now they can't throw mom out, and mom owns the property during the course of her life. Let's say kind of owns a lifetime interest in the property, so basically owns it during the course of her life. But can someone sit on the side
Yeah, that's a great
and,
question.
and lean up the remainder interest. I think it'd be hard in a way because maybe son could establish primary residence of that house upon mom's death and paper the public record to that effect. But it's an interesting question. I'm not sure it's really an asset protection move like Eric said.
Yeah, I think if, for son moving into the house and because homestead is so broad in Florida.
Yeah.
But they serve a purpose. I've done them in the past. I hope that answers your question. If you have more on that, or if you have questions about that, go ahead and shoot one of us an email offline here. All right. So as we come to the close, let's just trusts. We've done. This is a big topic. People are really interested in this. So we've done a couple standalone seminars and webinars on trusts. We just did one recently on domestic asset protection mechanisms, which included a big portion of trusts. And we say in our commandment 9, know who and how to trust, and that really has a lot to do with looking at the errors that people make, especially with self-settled trusts. The example there is this Huber case out of Washington, where a guy forms an Alaska self-settled trust. He's a Washington resident. His assets are in Washington. He picks a trustee that's in, co-trustees, one of whom is in Washington. Then he files for bankruptcy in Washington, and surprise, surprise, the Washington court says, well, whatever, it's an Alaska self-settled trust, but you're here in Washington along with everything else, so we're going to apply Washington law. And the upshot of that is that with the application of Washington law, which does not recognize self-settled trusts, the court invalidates the trusts and essentially considers those assets the assets belonging to the grantor. That's Huber. We've cited that in prior webinars.
So that's a very telling case, but we don't know what would have happened had Mr. Huber had an Alaska trustee now and had his assets in Alaska, because probably we would be listening to the judgment of an Alaska court under its own statute, which would be more helpful. Maybe not in his case. In his case, he actually had some fraudulent transfer issues. He didn't really plan very well, but we haven't seen that kind of a case where the trustee was in the state of organization and the grantor and the beneficiaries all had a link to that state.
All right, we got another question here. Let's see. Oh, this is a follow-up on the Ladybird Bead. If the son has a contingent remainder interest, since mom can remove him at her leisure, then son's interest would not be subject to his creditors.
Yeah, that's right.
Yeah, I'm not sure once she signs that deed.
That's not a Ladybird.
To son, not the deed. Well, once she signs the Ladybird deed, but actually you keep it revocable.
That's not a Ladybird.
That's a different situation.
Yeah, this means she can turn off the Ladybird whenever she wants.
If his interest is contingent remainder. Yeah. Right.
So either he gets it upon death or he doesn't. I guess it could read sometimes in some way that if in fact I die, he gets it, which is interesting, which would be an interesting take on that. You know what I mean? I can turn it off whenever I want. Let's see, remainder interest, since mom can remove him at her leisure. So it's a revocable remainder interest.
Sure, if the creditors show up, I mean, there's other ways around.
He would be removed.
He could be removed.
Yeah.
He could take she could change it to a joint tenants with rights of survivorship to pass it to him outside of probate, and where it would automatically take. I don't think the creditors could step in the way of that. So there's other things she could do.
Well, they probably could. They probably could they probably could claim some interest in his survivorship right if it's not contingent.
If it's
the same kind of thing. That's the Ladybird. But this is contingent. She could turn it off. So if it affects your estate planning, typically that contingency will not affect the reason for doing the Ladybird deed. That contingency will bring that asset back to mom for all purposes, pretty much, except for the transfer at death. But that would work. Yes, that will work in terms of asset protection.
So Okay, hope we answered that. If you have any further questions other than that, again, please contact us. And no other questions. Trusts, just some of the issues we've covered. Be aware of where the people and the assets and everything are. Okay, good. We got another one. All right. So what's this? What's the next question here? So I'm going to pass forward to the question. Sorry, we didn't cover all 11 commandments. We got to figure out how to do that in an hour.
Yeah.
All right. Let's see. So how about a grand deed transfer forgery? Is it common? And what are our transfer forgery? Well, if it's a forgery, it's invalid. A forgery is not going to be recognized if you prove that it's a forgery. That's going to be one of your issues. It's going to just invalidate any type of transfer. I'm not quite sure what the question is, but I can tell you that any illegal, anything done by forgery, by fraud and deceit is going to be likely void. There's a distinction between what's void and what's voidable, but I think that's going to be void on immediately.
Ab initio.
Void ab initio. That's the Latin phrase for it. All right. Well, our contact information is on the screen right there as we come into a close. If there's any last minute questions, throw them out there. But I'm Eric. I'm joined by Gary, and
hope you enjoyed it.
we have our new email addresses, but our old ones still work. Join us next month. We're going to keep doing the webinars. We're going to change a little bit. We're moving away from asset protection for a little while. Gary and I are still going to write on it. We've got some projects in the works, and we're
not divorcing.
We've got a seminar. We're doing a private sit-down roundtable for some folks in maybe 2 weeks, and we're happy to come speak to your group. And then Skip Sell and I next month, the wave of litigation that's popping up around website issues, compliance, terms and conditions, privacy policies, privacy issues, and the new rising tide of ADA, Americans with Disabilities Act, litigation around websites. This is a hot topic, and we're excited to present. So Skip and I, for a couple of months, for about 3 months, are going to do a series on the various compliance issues with websites, and we think that'll be valuable for anybody that has a website. If you look at ours, you'll see that we have a notice on there for the ADA, and I would say that I'd recommend everybody do that, because we're going to see a lot of litigation in the next couple of years.
That's a good one. That's a good one for business owners. Really good seminar.
Yes, please feel free to invite your clients to watch that. And thanks again for joining us over the last several months. And for today, if you have any questions, we welcome them here at the office, and connect with us on LinkedIn. And with no further ado, or hairdo, or any other Mountain Dew.
How do you do?
All right. Thank you.
Take care.
Have a great rest of your day. Thanks, folks. Bye-bye.